Good afternoon and welcome to the live proceedings of the Senate. This being an afternoon sitting of the House on the 16th of July, being a Tuesday afternoon, the year is 2024. We are glad you're watching. And before I take you through the highlights in the order of business this afternoon, remember you can equally get this live broadcast courtesy of our YouTube channels. That is on KBC Channel 1, as well as courtesy of the Senate of Kenya on YouTube. And you can also follow up on this live broadcast courtesy of our Signet channel, that is Senate TV. In the order paper this afternoon, the House will be debating a motion on the current state of the nation. This is a motion by the Senate leader of the majority party, as well as the Senate leader of the minority party. This is a motion that the House is set to resume debate on this afternoon. In this particular motion, the duo, that is Senator Aaron Cheriot, serving as the Senate leader of the majority party, and Senator Stuart Mazayo, as the leader of the minority party, want the House to call upon the National Assembly to expeditiously consider the presidential memorandum pursuant to Articles 115, subsection 2A, that all government ministries, departments, as well as agencies and constitutional commissions, including Parliament, to put in place austerity measures in undertaking their respective functions. The other issues is that the Ethics and Anti-Corruption Commission, EACC, and other government multilateral sector agencies in matters governance, justice and law, and matters other sector, to upscale and make concerted efforts to fighting issues to do with corruption. The other issue the House wants addressed is matters to do with abductions. That the National Police Service do seize abductions, unlawful arrests, extrajudicial killings, and increase, as well as exercise restraint in dealing with peaceful and unarmed demonstrators. The National Police Service is also required to release all persons arrested for planning and participating in peaceful demonstrations relating to the enactment of the finance bill. The government is equally required to waive hospital bills for persons who have been injured and defray funeral expenses for those who lost their lives during the demonstrations, and that the judiciary do prioritize and expedite all court cases relating to the enactment of finance bill and the resultant of the demonstrations. The House also wants the national government to make the considerations of all the challenges facing the country and make necessary recommendations to address them. The report of the Select Committee on Delegated Legislation on its consideration of the Social Health Insurance General Regulations of 2024 and the Social Health Insurance Tribunal Procedure Rules of 2024 is a motion by the Chairperson, Select Committee on Matters Delegated Legislation, Honorable Mwenda Gataya, popularly known as Mofaya. In this particular motion, the Committee on Delegated Legislation, through its chair, wants the Senate to adopt its report on its consideration of the Social Health Insurance Regulations of 2024. The committee already laid its report on the table of the Senate on the 2nd day of July 2024, and that pursuant to sections 18 of the Statutory Instruments Act of the Senate, Do resolve that the National Health Insurance Regulations of 2024 and the Social Health Insurance Tribunal Regulations of 2024, legal notice number 48 of 2024, be considered by the House. The business is just about to commence at the Senate. Senate Speaker, Honorable Amason Kingi, is presiding over the business this afternoon. Allow me to hand you over for this live broadcast, brought to you by KBC in partnership with PBU. Enjoy your viewing.
Za uongozi katika jamhuri hii yetu ya Kenya. Tukuomba tuwajalie tuyatende na kufikiria mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, we have quorum. Sergeant at Arms, kindly ring the quorum bell for 10 minutes.
The Speaker of the Senate, Honorable Amason Kingi, currently presiding over the business of the Senate this afternoon, has directed the Sergeant at Arms to ring the quorum bell this afternoon, owing to the fact that, pursuant to the standing orders of the House is not properly quorated. We need at least 15 senators in the chambers this afternoon for the House to commence business this afternoon. And as we await to see if that number will be attained this afternoon, allow me to take you through the other agendas for consideration this afternoon by the House, where, away from the motion by the Committee on Delegated Legislation on its consideration of the Social Health Insurance Regulations of 2024 and the Social Health Insurance Tribunal Procedure Rules of the year 2024, the House will equally resume debate on the Houses of Parliament Bicameral Relations Bill, this being a bill from the National Assembly, Bill number 44 of the year 2024. The Public Finance Management Amendment Bill, Senate Bills number 40 of the year 2024 by Senator Hamida Kibwana, is equally another bill set for a resumption of debate this afternoon. The Street Vendors a Protection of Livelihood Bill, Senate Bills number 41 of the year 2023 by yet another nominated senator, Senator Esther Okinyuri. And the Constitution of Kenya Amendment Bill number 2 of the year 2023. This is Senate Bills number 52 of the year 2023 by Senator Achimera, another nominated senator. In that particular bill on the Constitution of Kenya Amendment Bill number 2, before we look at the bills in the details, the Heritage and Museums Bill, Senate Bills number 8 of the year 2023, is another bill lined up for debate this afternoon, and so is the Agricultural and Food Authority Amendment Bill. This is Senate Bills number 13 of the year 2022. We'll be having a a couple of reports set for tabling. And among them is the annual report of the Parliamentary Service Commission for the financial year 2022-2023. This will be done by the Senate Leader of the Majority Party. And the Senator for Nyandarua County, Senator John Methu, will be passed on to Standing Orders number 53, subsection 1 of the Senate, be seeking a statement from the Standing Committee on Matters Health concerning the state of health and the health sector in Nyandarua County. Another motion lined up for debate this afternoon is the report of the Standing Committee on Matters Health on the inquiry into the alleged irregularities in the procurement of long-lasting insecticide. These are treated nets at the Kenya Medical Supplies Authority. This will be done by the chairperson on the Standing Committee on Matters Health, Senator Jackson Mandego, whose committee, through the chair, wants the Senate to adopt the report of the Standing Committee on Health on the inquiry into the alleged irregularities in the procurement of the long-lasting insecticide treatment and treated nets at the Kenya Medical Supplies Authority, KEMSA. The Committee on Matters Health already tabled its report on the table of the House on the 8th of May, the year being 2024. The House will this afternoon resume debate on a motion. This motion pertains to the report of the Standing Committee on Matters Finance and Budget on its status of the implementation of projects funded by the conditional grants for the construction of the county headquarters. The report of the Select Committee on the County Public Accounts on its consideration of the report of the Auditor General for the financial statements of West Pokot County Assembly for the financial year 2018-2019, as well as the reports of the Auditor General on the financial statements of Isiolo, Kiambu, Kitui, Marsabit, Narok, Nyamira, Trans Nzoia, West Pokot, and Murang'a County Assemblies for the financial year 2019-2020 is another motion that the House is set to resume debate on this afternoon. The County Public Investment and Special Funds on its consideration of the Auditor General reports on matters pertaining the water service providers for the year ended 30th of June 2019, 30th of June 2020, and 30th of June 2021 is another motion that is set for debate this afternoon. The quorum has been achieved. Allow me to hand you over for this live broadcast. Enjoy your viewing.
Clerk, proceed to call the first order, please.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, papers.
The Majority Leader.
Mr. Speaker, sir, I beg to lay the following paper on the table of the Senate today, 16th of July, 2024. This is the annual report of the PAC for the financial year 2022-2023. Mr. Speaker, I beg to lay.
Next order.
Order number 6, notices of motion. Order number 7, questions and statements.
Senator John Methu. That statement is dropped. Next order. Okay. Order number 8 is deferred. Next order.
Order number 9, motion, report of the Select Committee on Delegated Legislation on its consideration of the Social Health Insurance General Regulations 2024 and the Social Health Insurance Tribunal Procedure Rules 2024.
That order is deferred. Next order.
Order number 10, the Houses of Parliament Bicameral Relations Bill, National Assembly Bills number 44 of 2023, second reading, division.
That order is deferred. Next order.
Order number 11, the Public Finance Management Amendment Bill, Senate Bills number 40 of 2023, second reading, division.
The order is deferred. Next order.
Order number 13, the Street Vendors Protection of Livelihood Bill, Senate Bills number 41 of 2023, second reading, division.
The order is deferred. Next order.
Order number 13, the Constitution of Kenya Amendment number 2 Bill, Senate Bills number 52 of 2023, second reading.
That order is deferred. Next order. Which one? Okay. Now, Honorable Senator, we are now handling order number 13. That is the Constitution of Kenya Amendments number 2 Bill, Senate Bills number 52 of 2003. The floor is open. The Constitution of Kenya Amendment number 2, Senate Bills number 52 of 2023. If there's no senator willing to contribute, is the mover present? So we defer. Next order.
Order number 14, the Heritage and Museums Bill, Senate Bills number 8 of 2023, second reading.
The chairperson, Standing Committee on Labour and Social Welfare.
Mr. Speaker, not ready yet.
What do you mean you're not? ready yet.
I've just got the paper.
It
I don't
is
even know
your
it is.
It is your order. You submitted it to SBC. SBC has listed it for processing, for prosecution.
I can't even find it.
All right. Do you want to defer your business?
Yes.
Laura is deferred.
To defer.
Let's move to the next order.
Order number 15, the Agriculture and Food Authority Amendment Bill, Senate Bills number 13 of 2023, second reading.
Senator James Murango. The order is deferred. Next order. Next order, clerk.
Order number 16, the County Hall of Fame Bill, Senate Bills number 18 of 2023, second reading.
Senator Miraj. That order is deferred. Next order, clerk.
Order number 17, the Rice Bill, Senate Bills number 19 of 2023, second reading.
Senator James Murango. The order is deferred. Next order.
Order number 18, the Law of Succession Amendment Bill, Senate Bills number 20 of 2023, second reading.
Senator Veronica Maina.
Honorable Speaker, thank you for this opportunity to debate the amendments that I have proposed on the Law of Succession Amendment Bill. Mr. Speaker, at the very onset, these amendments...
You need to move fast.
Yes. Honorable Speaker, I move that the Law of Succession Amendment Bill 2023 be read a second time. And Honorable Speaker, at the very onset, the purpose of this Law of Succession Amendment Bill is to amend the current provisions under the Law of Successions Act to align it with the current marriage and matrimonial property laws. And the bill also proposes to safeguard gender equality in the succession matter so that widows and widowers have equal rights upon the demise of a spouse. Honorable Speaker, at the very onset, we need to take note of the fact that the current laws of Succession Act have not been in tandem with the matrimonial properties law and have not been in tandem with the current marriage laws. Why do I say this, Mr. Speaker? Because if you look at the Kenyan, the jurisprudence in Kenya, or the legislative jurisprudence in Kenya, under the marriage laws, you will find that we have a monogamous system of marriage, which is prevailing. And in this monogamous system of marriage, it defines who is a wife. It defines who is a husband, Mr. Speaker. And it defines a monogamous marriage as that marriage that is of one man, one woman. But when it comes to current practice, Mr. Speaker, you will find that even in situations where a man is married under the monogamous laws, you find there is either another wife who is under the traditional system or polygamous system, and you will find that there are children that may emanate from such relationship. On very worst scenario, Mr. Speaker, you will find that maybe a man who is married to one wife under monogamous laws of marriage also has mistresses and has had children or has had children out of wedlock. What has happened then is a sort of what I would call a chaotic platform on how determination of rights under succession law then happen to experience, because peradventure, if that man departs from this world, Mr. Speaker, you will find that even children who are born out of wedlock cannot then become inheritors of the estate of that man. So you will find the very, would I say, famous scenario of the little boy child in black suit and bow tie showing up in a funeral, Mr. Speaker, and for the first time, the family of this man experiences other children who are claiming from the man, purporting that the deceased was their father, Mr. Speaker. In many instances, you discover that actually those children could belong, their paternity can be traced to the man who has departed. So the purpose of this law, Mr. Speaker, is first of all to determine what should happen to children who are born out of wedlock. And number two, are the women who have given birth to these children entitled to the estate of the man who is now deceased, Mr. Speaker. And because the law of succession, on the other hand, recognizes monogamy, recognizes polygamy, recognizes children who are born out of wedlock, recognizes other beneficiaries who may have been dependents of the deceased, then, Mr. Speaker, what has happened is that we have had a clash of laws between monogamous laws and the succession laws. So the purpose of this amendment is to align some of those areas. Mr. Speaker, it's also to look at the Children's Act and look at the Constitution, what the Constitution provides for children, whether children, once they are born from a certain lineage and from a certain paternity, are those children as entitled as those who are defined as children under the monogamous law. So, Mr. Speaker, in Section 3 of the Succession Act, that is the Principal Act, we are proposing, Mr. Speaker, an amendment to redefine who a child is. That child to include an adopted child, and that child to also include a child who is conceived during the lifetime of a deceased person and is subsequently born, even if they are born after the death of the deceased person. What does that mean? That if a man was to pass away, when the wife is pregnant, or not even the wife, or even a woman he impregnated, then if that child was conceived by the person who is deceased, Mr. Speaker, or departed, then it means the definition of a child will now include anybody who carries his DNA, Mr. Speaker. Is that important? If we look at the Constitution, Mr. Speaker, a child who carries the DNA will be defined in the Constitution as a child belonging to that person or to that man, and will be entitled to be an inheritor of that estate, notwithstanding that his father passed on. So we'll be seeking a redefinition to be more inclusive, and we're also looking at an adopted child, Mr. Speaker. An adopted child is that child whom the parents have assumed legal responsibility over, a court order has been issued, and that child is now defined to have adoptive parents who are then recognized through a full adoption process in court. Once that child is departed, they become equal or equivalent to the children who are born by the couple or who are born by the man who has adopted them or who are born by the man and the woman, or who are assumed, the parental responsibility is assumed by the man and the woman who have adopted, the couple that has adopted that child. So, Mr. Speaker, this definition now is expanded because even though the law had not expanded this definition, many lawsuits have been taken to court to define who a child is. So the law will now clarify that an adopted child should be treated as a child of that couple and should have equivalent rights with the biological child of that couple. Mr. Speaker, in the Principal Act, there is now the term intermeddling, which is introduced, Mr. Speaker, and defined what it means. The intermeddling is in relation to the properties of the deceased. Mr. Speaker, our courts are replete with a lot of data of cases that have been brought before courts at the instance of offenders who are intermeddling with the estate of the deceased. And we know them, even where cases have not been preferred, even where disputes have not been recorded. Yet we know in many family barazas, Mr. Speaker, we have had instances where relatives who perceive themselves to be stronger than the widow, for instance, will intermeddle with the estate of the deceased. And Mr. Speaker, I think every single senator in this House has come across many cases, Mr. Speaker, where the property of the deceased person is interfered with, possession taken, the property is being disposed of, somebody else is trying to forge a title, even charging the property, or even collecting the rents, or collecting any benefits that are emanating from such properties, Mr. Speaker. The concept now of intermeddling has been redefined better in these amendments. They have been redefined to mean taking possession of, disposing of, charging, receiving, distributing, leasing or using property of a deceased without authority under this act or any other applicable law, or even ejecting a surviving spouse or a child from the matrimonial home or matrimonial homes, Mr. Speaker. From the stakeholders' engagement we have received from different actors in this field, Mr. Speaker, they have even proposed that this definition should even be expanded further to include any act or any action of ejecting a surviving spouse or a child from matrimonial homes or matrimonial properties, and any other action that may be deemed to become unlawful as it concerns with dealing with the deceased person's estate. So that means it will no longer be business as usual once this amendment is enacted. If somebody intermeddles with the estate of the deceased, then it means there will be criminal culpability. It means there will be penal sanction, Mr. Speaker, so that those big brothers, and I apologize for using the big brothers because they are the ones, maybe, or male relatives who have really oppressed widows who are vulnerable and who are busy mourning their husbands, Mr. Speaker, can then now take a back seat and consider whether they can take the criminal sanction that will emanate from such behavior. And that would as well mean, Mr. Speaker, after these amendments are introduced and accepted and adopted, Mr. Speaker, as part of our laws and enacted as such, it will then mean that those widows who have cried for many days, who have been thrown out of their estates, whose children could have been thrown into the streets by other relatives, Mr. Speaker, that will become a thing of the past. We have seen on many occasions that widows will not only be thrown out of the properties, you will even find that some very treacherous relatives or distant relatives have walked in, carted away a vehicle, even carted away movable property, carted away furniture, or even started commotion and very heavy fights, which are even evident in burial ceremonies, Mr. Speaker. So after this becomes law, it means that if somebody intermeddles with the estate of the deceased, then it means it is not going to be acceptable and they can be prosecuted for that, Mr. Speaker. Mr. Speaker, many lawsuits have been taken to court and not many people have been punished enough to send a message to the ones who are intermeddling with the estates, Mr. Speaker, that this should not happen. There are some estates in the Republic of Kenya, actually, which are notorious, Mr. Speaker, especially when you find an estate has many assets. I do not want to name them because of data protection, Mr. Speaker, but Kenyans would understand the number of estates which have become notorious for making headlines because of relatives intermeddling or taking shares that do not belong to them. Once this act becomes law, then, Mr. Speaker, it is going to be way better and this area will be settled. When this bill was read for the first time, Mr. Speaker, a number of people called me to congratulate and compliment the fact that Senate is thinking about amending these sections of the law because of the pain they have had to go through as they watched people who are not related to the man, the holder, or the deceased spouse, to watch people who just come to claim. They claim things that don't even belong to them. They did not even know the deceased very well. But suddenly, Mr. Speaker, they come into intermeddle. And the intermeddling, Mr. Speaker, will also mean that any person who is entrusted with being an administrator of an estate of a deceased person will also have to be more accountable on how they manage the estate of the deceased. So this, Mr. Speaker, will debar any ambitious criminals and any person who would wish to take advantage of the fact that the man in that home is already demised and take advantage of vulnerable children. You have seen estates, Mr. Speaker, some of them have only minors. Minors are left. Children who are under 18 years. Even before these children understand what their father owned, we have seen on many occasions, by the time those children grow up, the estates cannot even support their education. Those children who are being provided for, going to an ordinary school maybe, living in a good estate, or living in a sensible estate, we find all of a sudden the demise of their father or demise of their parent means that they can no longer enjoy the basic maintenance that they were being given by their parents. So it will throw a lot of cushion and a lot of protection to such vulnerable members of the family. Mr. Speaker, it proceeds on under Section 35 to be amended, Mr. Speaker, to enable that the interest of a surviving spouse to be determined upon remarriage. Mr. Speaker, if you look at the current Law of Succession Act, that interest only determines on the side of the woman. When a widow remarries, the interest in the estate is determined upon her remarriage. But the current provisions do not provide for that determination to be on the widower. It only determines on the woman's side. That means it's biased and not equitable to both genders. So the proposed amendment now, Mr. Speaker, is such that the interest of the estate shall determine for both upon remarriage. So that if the interest, for instance, if it's a widow who has remarried, because the interest would remain with the children of the couple before the man passed on, then it means even for a widower who gets married, that interest is determined. So it gives an equality in law, treating the man and the woman the same way. But in the current laws of succession, Mr. Speaker, it has not been treating the man and the women equally. That is the widow and the widower. So the introduction is for both of them, the determination is upon remarriage. Mr. Speaker, there is also another amendment where the surviving child is not a child of the surviving spouse. Where the surviving child is not a child of the surviving spouse, the surviving spouse shall be entitled to the personal and household effects of the deceased absolutely, and a life interest in 1/2 of the whole residue of the net estate. And the surviving child shall also be entitled to one half of the whole residue of the net estate, which shall be held in accordance with section 41. And if there be more than one child, they shall share equally. Meaning, if for instance you have 4 children or 2 children, those children would share equally, and each of them you take a part. If there are 4, they take a quarter each. And a further introduction is where the surviving children include a child who is not a child of the surviving spouse. The surviving spouse shall be entitled to the personal and household effects of the deceased absolutely, and the net intestate shall in the first instance be divided equally among the surviving spouse and all the surviving children, and the surviving spouse shall have a life interest in his or her share and that of his or her children under the subsection that is cited there. And Mr. Speaker, a further amendment is that the share of the surviving child, who is not a child of the surviving spouse under subsection 1B, shall be held in accordance with section 41, and if there be more than one child, they shall share equally. You will notice, Mr. Speaker, the amendments are introducing an equality clause and treating all children the same way. Mr. Speaker, there is also another amendment under section 36 of the Principal Act. And Mr. Speaker, in this section 36, a lot of case law has determined that, Mr. Speaker, even after a spouse has passed on, the estate of that spouse will be held by the surviving spouse until the date when that surviving spouse remarries. But then, Mr. Speaker, in a scenario where both the spouses are not there, what happens to the estate? Now, in the current Law of Succession Act, that estate first goes to the father of the spouse who has passed on. What the amendments are seeking to introduce now is that such an interest, Mr. Speaker, will be shared between the father and the mother in equal measures, or if either is dead, the surviving parent. For instance, in instances where it was the father to take the net estate of the spouse who passed on, in these amendments, Mr. Speaker, it will now be the father and the mother to have that estate in equal shares. And if either of them is dead, then the surviving parent can have the share of the spouse who has passed on, or their daughter or their son who passed on. In the instant that there are no surviving parents, then the brothers and sisters. Before, Mr. Speaker, it leaned more towards a patriarchal tendency. It had a patriarchal tendency towards who holds the estate, the residue of that estate. What this amendment has now done is to put the brothers and sisters in equal measure, and any child or children of deceased brothers and sisters in equal shares. And this is important because, Mr. Speaker, you'll find sometimes the estates which are being distributed are actually not estates of the immediate parents of the people who are inheriting those estates. Sometimes you find even grandchildren are inheriting estates of their grandparents when there is no other surviving relative. And if it's half-brothers, it is half-brothers and half-sisters, and any child or children of deceased half-brothers and half-sisters in equal measures. All the relatives who are the nearest degree of consanguinity up to and including the 6th degree in equal shares. So that when you have one generation, Mr. Speaker, which has all died, then it moves to the next degree, which is the next generation maybe of the grandchildren, and from the grandchildren it moves to the next step of generation. This is the one that is referred to as the relatives who are in the nearest degree of consanguinity up to and including the 6th degree in equal measure. What it has done, Mr. Speaker, this amendment, is to levelize between brothers and sisters, sons and daughters. And Mr. Speaker, just to assure you that these are the right amendments, if you look at the case law that has been generated from the court, they have been more progressive than the legislation itself, because the courts have upheld now that the definition of a child is not just the boy child. It's a boy child and a girl child. So that, Mr. Speaker, if I have one boy and one girl, the law will treat them equally as my children, and none will have priority over the other. It's a very good amendment, Mr. Speaker, especially when you look at the population demography, because we have 50-50 or slightly more women than men. That means in any home, you will find their sons and their daughters, Mr. Speaker. And they are now being treated equally, a fact that has been happening in court anyway. And so what we are doing with this amendment, Mr. Speaker, is to ensure that what the law, the precedents have taken, the progression that the legal precedents have taken, Mr. Speaker, can be captured as correct legal principles applicable and making it more easier in distribution of the estates of deceased person. Mr. Speaker, the next amendment is under Section 40 of the Principal Act, and it has new subsection, a subsection 3, that notwithstanding subsection 1, where any of the surviving child is not a child of any of the wives of the deceased, that child shall be considered as an additional unit in determining the share of dependents in the net estate under subsection 1, and the share of such child shall be held in accordance with section 41, and if there be more than one child, they will share equally. The assurance that I once need to throw at this point is that it is the children who are sharing in the estate of the deceased. There was a bit of concern from women when they saw these amendments, because the women who happen to be, for instance, like myself, one wife, monogamous marriage, you don't anticipate another woman. They were very officially. They were a bit in a shock when they saw the amendments. I have seen how my brothers have laughed here, and they look like serious defendants for these amendments, Mr. Speaker. They look a bit guilty, Mr. Speaker, but I will interrogate each of them on their personal laws and their belief system and what they are keeping around them, the company they are keeping around them. Mr. Speaker, because when then a wife does not anticipate another woman coming to compete for the husband's attention or the husband's estate, Mr. Speaker, they were very concerned about these amendments. And one of the concerns was, are you now introducing strangers to our homes? Because the women will feel these are strangers, but they may as well be strangers to the women, but not strangers to the men in those homes, Mr. Speaker. And I had to quickly assure that it is not the woman who is coming in for the estate of the deceased. It is the child who has been fathered through the paternity of that man. And what does that mean, Mr. Speaker? When a man now decides to keep an affair out there, they must understand the full consequences of that affair. That if you decide to father another child, you will bear the weight of that responsibility. Not just now, but even to the next level. And Mr. Speaker, Senator Boni Halwale is very vocal about this subject, and I will not disclose the number of wives he has. But, Mr. Speaker, what this act of amendment is also doing is the fact that the Children's Act, as it stands right now, we all know how busy the Children's Court is right now, because any child who is fathered by any man, once the man fails to provide, they usually have a redress under the Children's Act. That is already happening, and maintenance is being done openly or secretly for those children, Mr. Speaker, who have been fathered by different potential defendants, maybe even in this house, Mr. Speaker. So what the law of succession is doing now, it's taking away the confusion that we have seen in burial ceremonies, in funerals. You see, when a person has passed on, there is another one who runs to court to stop the burial until issues are determined. It may as well be, Mr. Speaker, that when these amendments are effected, you will have less lawsuits of stopping burials because, like we have always said, there may be no asset in a dead body, Mr. Speaker, but since many people may not understand that, they normally first run to stop the burial, saying that all the issues must be resolved. And part of the issues they will seek a resolution on, Mr. Speaker, will be how will the rights of this child be catered for, because this man lying in this casket is the father of this child. So what these amendments you do, Mr. Speaker, they can now pose anybody who is running to stop a burial and to know that there is legal protection for the child, not for the wife. Because in the law of succession has defined who a wife is. It has defined who is recognized as a wife and who is a wife. And if you are not defined as a wife, it is not possible for one then to push for a portion of inheritance from the estate of the deceased. But for the child, the law will now treat the child differently and in a fair manner, so that if the DNA of that child belongs to the man who is demised, Mr. Speaker, then it means provision has to be done. But is that child treated better than the other children who are in the officially recognized home? No, no, no. Mr. Speaker, those children will be treated equally. If it's education, they are provided for it. And that is provided for under the Children's Act. And Mr. Speaker, I know I've heard of this concept of a gentleman talking about nyumba dogo. Kuna nyumba kubwa na nyumba dogo. Now nyumba kubwa is the one which is the formal one, Mr. Speaker. The one that is known by the public. The wife who is taken to the weddings, to church, to shopping. And then there is usually this concept of nyumba dogo, the one that is secret, unknown by everybody. And Mr. Speaker, what this will straighten, because the culture now could as well be very notorious in Kenya, Mr. Speaker. What these amendments you do, Mr. Speaker, is to ensure that we do not have children who are not being taken care of when their fathers are walking free and may be happy. And Mr. Speaker, because we should not be creating as a society despondency on these children, it is important that every child is taken care of, and every person who has fathered a child then takes care of that child and does not expect another person in another home to take care of their own DNA, Mr. Speaker. So it's putting the chips where they should fall, Mr. Speaker, that if you have sired a child, then take care of the child. So, Mr. Speaker, we are proposing this amendment, Mr. Speaker, and we hope that the backlog of the cases we have seen in the family law division, Mr. Speaker, is going to be sorted courtesy of better laws. And further, Mr. Speaker, is to say the case laws that are there are the ones that have inspired these amendments, that the courts have already been holding judgments and following precedents that are aligned to this amendment, Mr. Speaker. These amendments have been supported by many stakeholders, Mr. Speaker. The Widows Association have supported these amendments. FIDA Kenya has supported these amendments, Mr. Speaker. Different associations have supported these amendments because they are going to levelize the rights, protection of rights of the children. So, Mr. Speaker, a wife who is not a wife will not manage, Mr. Speaker, to claim anything under these new amendments. And we will eliminate discrimination against widows, Mr. Speaker. And sections 35 and 36 of the current Law of Succession Act have actually been found unconstitutional for discrimination on basis of gender. And therefore, the bill also seeks to ensure that the widow and the widower have their life estate, their life interest in the estate, and it determines upon their remarriage, Mr. Speaker. And this is a very sensible amendment because, Mr. Speaker, for instance, if a senator, a woman senator, passes on and maybe had a mortgage and bought a home, and she passes on and leaves the husband, and that home is left to the gentleman, if this interest does not determine when he remarries, Mr. Speaker, there could be a possibility that even that home will no longer be used for the children of the widow when she passes on. Now, this law will ensure that such a home will now not be left with the interest of the widower, but will be left in trust for the children of the woman who has passed on, Mr. Speaker. And that means it's going to bring justice and a lot of equity, Mr. Speaker. I know there is one question that pens about matrimonial property. Supposing a property was defined as a matrimonial property, and a man has passed on, and that property was determined, and the widow now has remarried. And in that matrimonial property, for instance, and in line with the judicial precedent that was held by the Court of Appeal, I don't remember the name of that lawsuit, Mr. Speaker, from on top of my head, the woman has contributed, say, 30%. What you determine at the point when this man remarries is the portion in that matrimonial property which belonged to the woman. The portion that belonged to the man who is now a widower will still be retained by the man. But the 30%, for instance, if the woman would have demonstrated to the court that 30% of that property was contributed to, and she was entitled to an apportionment of that 30%, that 30% will then determine in favor of the children of the woman maybe who has passed on, or the man who has passed on. So this law does not seek to bring inequality, but it seeks to bring equality, Mr. Speaker. I also wish to note that the court had previously found Section 39 to be unconstitutional insofar as it gives the fathers the priority when it comes to inheriting the property of their deceased children. It now means that the father and the mother of the deceased child will be able to inherit. Notably, Mr. Speaker, there is a section in this bill that has excluded community land from the ambit of succession. You know, in some counties, there are some counties where community land has been excluded from the family law and succession. For instance, in pastoralist communities and in counties like, say, West Pokot or parts of Kajiado, where there is community land that is for grazing, it cannot be subjected to the terms of this, to the provisions of this Law of Succession Act. That means the amendment is still not breaching the rights under community land, and the community land continues to be protected and out beyond the ambits of these amendments. Mr. Speaker, I would pray and hope that my colleagues, the senators in the House today, would find the sense in the proposed amendments and would support them so that, Mr. Speaker, we can then say spouses, surviving spouses, and children will no longer be ejected from their homes, matrimonial homes, when their father or their mother has died, and that instead of them being ejected, we will see more compassion from the society. We will see more compassion from the relatives who have, in other instances, taken advantage of such vulnerable families, Mr. Speaker. And ejecting would mean, Mr. Speaker, if the definition is opened, would mean, for instance, that even persons who interfere with accounts, for example, Mr. Speaker, supposing somebody had access to accounts of a deceased person, I don't know, for some reason, in many families, Mr. Speaker, when you find disputes within the family, you find even spouses are entrusting outsiders with their resources. They entrust them. They make them attorneys to sign bank accounts, and they cannot even entrust their wives with the signing of those bank accounts. the intermeddling will mean, Mr. Speaker, that even a person who has access to sign accounts for that man or for that woman, and after the demise of that man, they decide to clear that account, Mr. Speaker, this act will still be able to reach out and punish, Mr. Speaker, any such actions, Mr. Speaker. There has been a debate on what should be the penalty of a person who then intermeddles with the property of the deceased, Mr. Speaker. And I'm sure, Mr. Speaker, when we come to the Committee of Whole, we look into the appropriateness of that account, because finding 10,000 is not good enough. I'm aware that JLAC should have presented a report, which is still coming, but I was duly advised, Mr. Speaker, that the report can come now, or the report can come even during the second reading. It can still come, Mr. Speaker, because it will inform the debate, and I'm sure the chair of JLAC, who is here, will be putting his comments on these amendments, Mr. Speaker. So by and large, Mr. Speaker, these are good amendments, and it is my hope and prayer that senators will support these amendments and will clarify the issues that have been bringing a lot of pain unabated for very many years, so that we can have more sense into the distribution of estate, protection of children's rights, protection of women, gender equality in terms of succession, Mr. Speaker, treating mothers and fathers of deceased children the same way, Mr. Speaker, and we will be able to make progress in the area of family law and succession. With that, Mr. Speaker, I beg to move these amendments, and I would request Senator Sigei to second this motion.
Thank you very much, Mr. Speaker. I would like to congratulate the Honorable Senator Veronica Maina for this very important amendment to the Law of Succession Act. Mr. Speaker, as I second, I would like to indicate that there are 7 proposed amendments to the Law of Succession Act, and as has been ably put forward by the mover of the amendments, Mr. Speaker, of a very critical concern and appreciation is the fact that these proposed amendments will be making the Act to comply with the various pronouncements which have been made by the various courts in the process of litigation by among many Kenyans who have had challenges with the issue with regard to succession, with issue with regard to matrimonial property, with the issue with the intestacy, because this is a country where a good number of Kenyans do not leave behind wills for purposes of the estate before they pass on. And Mr. Speaker, to be very particular, the amendment seeks to align the Law of Succession Act with the Children's Act by defining what the law now with regards to who a child is. This particular introduction of a definition of a child in the Succession Act is to ensure that adopted children can fit into the estate of a deceased person, whether father or mother, and for purposes of benefiting from that particular estate. Similarly, intermeddling of the estate in this particular proposal has been broadly defined to mean taking possession of, disposing of, charging, receiving, distributing, leasing, or using property of a deceased without authority under this Act or any other applicable law. Mr. Speaker, this particular expansion of definition is seeking to support and ensure that the very many cases which we experience where upon the demise of an individual, the estate is abused by either the surviving spouse or any other person who has got an interest, particularly in situations where that particular estate could be unknown or has not been disclosed to the family, and in ensuring that we broaden this definition of what intermeddling means, we are protecting the estate so that in the event that that was not disclosed among the properties of the deceased, the family can ensure that ultimately it will be protected. It has also expanded the definition of intermeddling to mean ejecting a surviving spouse or child from the matrimonial home or any other unlawful dealing with the deceased person's estate. Mr. Speaker, this is a very important amendment because without protection of the estate of a deceased person, the beneficiaries, the children, the surviving spouse, parents, or any other dependent on that particular estate will be left with nothing to survive or to inherit, especially where the law does not define beyond the abuse or any unlawful dealing with that estate. And the proposal by Senator Veronica to expand that is highly welcome in order to make sure that we protect these particular estates. Mr. Speaker, the proposal to amend by deletion of, in the Principal Act, Section 32, is one that is very critical. Section 32, Mr. Speaker, in the Principal Act provides for exclusion of certain counties, the county like Kajiado, Wajir, Marsabit, Tana River, in the Principal Act has been excluded, particularly with regards to some certain immovable property and agricultural land. The Act seeks to ensure that Section 32 and 33 does not exclude those counties in the aspects of reference to matrimonial property and also in terms of succession on agricultural land as well as movable property of a deceased person. This is in effect ensuring that anyone who is living within the territory of Kenya applies this particular law for purposes of uniformity and also in terms of ensuring that we do not abuse the existence and the application of the local regulations, the local laws, or even traditional beliefs as to who is entitled to participate in sharing or benefiting from a property of the deceased. The repealing of Section 32 and 33, therefore, of the matrimonial of the Law of Succession Act has ensured that there is uniformity in the application of law across the country. Mr. Speaker, further, the amendment to Section 35 of the Principal Act is as elaborately put by the mover to ensure that if a deceased person has left intestate, the spouse who is surviving with or without children are equally protected so that they don't lose on the entitlement merely because the law does not specifically and clearly provides for who in order of consanguinity is to benefit before the other. Similarly, the amendment to Section 36 of the Principal Act is to support and ensure that the surviving spouse as well as children and any other person who is to benefit from that estate is not denied of that entitlement merely because the law does not list as to who is to benefit first before the other. Mr. Speaker, under the proposed amendment to Section 39 of the Principal Act, the current law has listed the father before the mother. The proposed amendment herein seeks to ensure that both a father or mother of a deceased are equal in terms of their benefit to the estate, and therefore it proposes to say that once there is a deceased and they do not have a surviving spouse, it's the mother or the father in equal share who are supposed to benefit, and in the absence of either, then the rest of the list of the beneficiaries will apply. Mr. Speaker, I appreciate the proposed amendments by Senator Veronica, and as it has been stated, we have, as JLA committee, received various proposals and also concerns by stakeholders within their various areas of interest, and JLA committee report has already been concluded. it is awaiting adoption, and we will table it at an appropriate time so that should there be any additional amendments that we will seek to amend or introduce, it will still be done within the time that the laws and the standing orders of this House allows. As I second, Mr. Speaker, I once again want to appreciate and thank Senator Veronica for ensuring that we amend the law in order to align it with the developments within the law of succession sector, as well as the several pronouncements and decisions that various courts have made in the course of the litigation processes that have been in this country. Mr. Speaker, I support, and thank you for the opportunity. I second.
Honourable Senators, I now proceed to propose the question that the Law of Succession Amendment Bill, Senate Bills number 20 of 2023, be now read a second time. The floor is open. Senator Manzo.
Thank you, Mr. Speaker, for giving me an opportunity to contribute on this very important law and amendment. Mr. Speaker, the law of succession is the most controversial law in many parts of Africa. The law of succession keeps on being dependent on circumstances of each case. And that's why the judgments which has come out, and sometimes they are tailored to suit a certain issue presented in courts. And in a lot of times, Mr. Speaker, the courts is encouraged to get all the interested dependents, and then they are able to agree on a settlement. I want to look at the scenario which has been presented here. First, the definition of a child. That is correct. But then sometimes people who are above 18 years, who are no longer children, become dependent or are entitled to property of a deceased person. And then, Mr. Speaker, you find that in the event of a death of a child or a son, then it used to be father, and now it's going to be father and mother. So suppose that son, then he has a family. Then which way? And it becomes very complicated, and many of the matters which have been in court have been very strenuous. They take many years. All family or people who are entitled have to personally appear in court and state their position. And it's one of the matters which are extremely complicated. And again, Mr. Speaker, some people die and there's nothing to inherit. They have no property in their name at all. Sometimes, Mr. Speaker, you find it is a matrimonial property, and each spouse has a contribution to that property. So then, when it is a man who is deceased, and his share is so little, and the number of children other than the children of the wife are also entitled, again, it raises another complication. And it has been difficult, Mr. Speaker. Some people die testate with a will, and the will is still found not to be fair. And then the matter ends up being treated as intestate, and then goes back to square zero and raises a lot of issues. There has been many debates as to whether one should make a will or which way should they ensure that their property helps the children the moment they are no more. And Mr. Speaker, is always case to case, circumstances to circumstances. But I had one scenario I was given by a friend of mine. He's now deceased, but when his father died, who was a politician, he expected a lot of trouble at the funeral because his father was wealthy. And therefore, when he went to the funeral, he saw people pretty much looking like him, and he knew the time sons would be called, there would be quite a number. But to his surprise, these people just attended the funeral and left quietly, because his father had sorted out them before he had died. And at all material times, they knew the day of the funeral, there's nothing to come and share. They would just attend. And he was pleasantly pleased, because he expected there to be a lot of battles for their succession. And therefore, I think eventually this matter is determined from case to case, family to family. In fact, the Muslims have Islamic law, and the personal law applies to them. We have also people who the Succession Act may not fall into. Suppose then you are under customary law, and you are purely married under customary law, which is potentially polygamous. Then do you really fit squarely under the law of succession? So the law of succession has been left loose for many years, and with many loopholes. And an attempt by Senator Maina, a renowned lawyer and a senator we have a lot of respect for, to sort out a few loopholes, sounds like a case tailored to a certain class of people, and a case, which may apply or may not apply. So it's a good time for us to ponder, and I think when it comes to third reading, we really need to sit with the JLAC and her, and still think further according to the precedents being generated by the courts every other day. And even some people have attempted to leave their property under trust. The trust has become more complicated than a succession issue. In fact, now strangers come and loot the trust. And in fact, they get an opportunity to share the wealth, abandoning all the children. And then the matter drags in court, and every other time, anybody looking like they resemble the deceased, they come forth and say, we are also children of the deceased. Recently, we had a Kenyan from Ukambani who passed on in the U.S. And, although he never got married, some son claimed the estate, son in the courts. And after some time, it was discovered that this was a fake son. But they had already, gone through the court process and attempted to secure the estate of deceased, which was massive in the United States of America. So the case, this has to be case to case, and depending on how the owner of the property has handled the matter. And even nowadays, a lot of men are preferring, once they die, to be cremated, so that there is nobody to be fought for, or no one to stop any funeral. And even people have attempted to stop those cremations, but even after cremation, it is still not sorting the problem. Issues still arise, especially if the person had anything to be inherited. And we have also got situations where it is even difficult to realize the net estate because of debts, bankruptcy of companies, and a lot of, debts owed to that estate, so that there is even nothing to share or to distribute. And therefore, as much as you are talking about a child, the more practical thing in courts is children who are not under 18 and are still entitled to the estate, including now. So when in this particular proposal, we have a child, meaning one who has been born. We have a child, meaning one who is under 18, and they are probably going through schooling. Then that at its own place. But what do you do with the people who are adults, probably have their own children, meaning now the deceased has grandchildren, and all these people are claiming to have been children of deceased. So succession, is a tricky idea, is a very tricky issue, even where there has been a divorce. And there are still issues being determined as to what did the lady or man contribute into the empire they have. There are still uncharted areas by the courts. And every day the jurisprudence the jurisprudence of of these cases is still being developed. Unfortunately, Mr. Speaker, we lost a judge who was very, good at developing jurisprudence in any area he was working on. He will first work out on the jurisprudence and what laws could really apply. The Honorable Justice Bajaja, but unfortunately we lost him, as all of you know, and I'm told his service is tomorrow. In fact, I would really like to attend because I knew him from college and I appeared before him quite a number of times. But he was very good at developing jurisprudence. And I think in this case-to-case, then a jurisprudence has to be established or developed because there are so many incidental issues such that you may not be able to frame them and narrow them to an act of parliament. They keep on, generating and moving in different directions, case to case. Even when you define marriage, people who have lived together for 7 years and are regarded as husband and wife, the law also says there is presumption of marriage in that case. So somebody may have just cohabited with another for 7 years. They will go to court and establish that they were presumed married, and therefore then the succession issue ensue, and there may be people entitled to that estate. Going back to the Bible, when Abraham had another child, and eventually now Isaac was born, when the lady was being sent away after a dispute, she was given a lot of property. She was given an entitlement together with her son. They never left empty-handed. So that could be a basis of a jurisprudence on what could happen in scenarios like that. Then you had, the issue of when a woman passes away and she's the owner of everything. Then the man has also sad other children elsewhere. So then, it means when the man goes away, now that property has been left with a widower, then it means there are others who will come and claim, who are not part of it. So then how do you determine then how the lady who passes away, her children benefits? And suppose it happens, the lady passes away and not before even succession issues are sorted, the man passes away, then other children arise. So each case really, Mr. Speaker, has to be dealt on its own merit, circumstances, and it will be, in my own opinion, very difficult to fix strictly all the succession issues, marriage issues, to one place. Then the issue even of community land. Now we have law relating to community land. And the community land means no particular person has a title or is fully entitled to that land. So how does succession interplay with this within that community? Suppose some of the children sad out of marriage or within marriage do not belong to that community. Then there is the issue of father or mother. A son passes on and the property, if he had any, is given to the father while the mother is alive. So I think that introduction could help that the two of you then benefit. I don't even know what was the wisdom of leaving it to a father alone, because then it is a son who passes on, or a child, or somebody sad from that home. Could also be a daughter. And in fact, a lot of the scenarios play in the courts is where a daughter passes away who was not married and had no children and had property. And then probably whether she was married or not, or other people are making claims on that, then probably whatever would be the net estate then could come to their family where they were born. So these are very interesting matters which are mind-boggling to judges when they are trying to determine them, and is an area of law which is very debatable, Mr. Speaker. The proposals are a good attempt. Then when a widow remarries, that scenario. Somebody passes away, leaves a widow with a lot of property, then within a year or so, she's now married to a new man. Then what will be the entitlement? Will this property go back to the parents, or will it now move to the new man? Because she's likely to lose all of it to the new man. There's so many questions which you can't get answers unless you deal case by case. I really would like to support my senior and friend, Senator Maina, but we need to look at it more, further details during third reading, so that we can come up with scenarios applicable. And in Africa, the applicable culture is amazing. You know, community to community, there are different cultures which also come to play. When it comes to Islamic religion, it is very clear what must happen. But when it comes to succession and African culture, it has got a lot of many other issues which come up, and so long as that culture is not repugnant to justice, probably will be applicable. Therefore, Mr. Speaker, I beg to support, because it is my friend Veronica Maina, and she is likely to persuade me, but we really need to think and even employ experts, probably here. A lot of other opinions. I don't know what happened on public participation. Probably succession courts would have given a very big input into this, depending on the cases they have gone through and how wisely they have gone around them. But a lot of judges are encouraging and calling upon everybody interested to come to court, and then they agree on a way forward there as a family, and then they go and do as they have agreed. I thank you, Mr. Speaker. I support.
Senator Cheriot, Aaron.
Mr. Speaker, I'll try and be very brief. This is not something that you want to speak a lot of things about, because it is dodged with very many risky corners as you contribute. Mr. Speaker, you can be asked later to declare your interest in some of the provisions. Therefore, for the record, Mr. Speaker, it is important to say this is purely legislative work and no personal interest in it. But very thought-provoking listening to Senator Veronica Maina, Mr. Speaker, very distinguished legislator, and I love the work that she's doing in the Senate, Mr. Speaker. Many bills that she has proposed, this just being one of them, Mr. Speaker, and therefore I'd wish to indulge her in a few thoughts. Mr. Speaker, even before going into the very details of the various sections of the law that she is seeking to amend and the justification she gave, there's something Senator Manzo said in passing, but he didn't realize the gravity of the debate, actually, he was handling at that particular point, Mr. Speaker. Because one of the greatest challenges of the laws of succession, listening to it and even having just a cursory look into the issues that are before various courts of law, Mr. Speaker, and even in public arena, because it's not only in our courts of law, Mr. Speaker, that laws of succession are practiced. Even in villages, Mr. Speaker, where ordinary citizens who cannot access the courts of justice sit down and try to agree on some of these issues, Mr. Speaker, there are rules and there are challenges there. Senator for Makueni, my good friend Senator Manzo, did mention the conflicting application of this law in line with customary practices in our various communities. And this varies from one community to the other, Mr. Speaker. And it is unfortunate. I wish Senator Veronica perhaps had taken time to reflect on this as well, of how do we marry the law with these various customary practice. I know for a fact Senator Manzo comes from the Akamba people. And one customary practice that we share with them, with the people, where my own people, Mr. Speaker, is where back in the olden days, women used to marry other women. And it's not in the way that we are accustomed to now and the stories that we hear about all these other things, Mr. Speaker. But it was that when a woman is married, if for whatever reason she was not able to bear children, then she was allowed actually to bring in an aid or an assistant. And it's a practice that is established even in biblical practice, Mr. Speaker, because if you're a reader of the Bible, you know what happened between Sarah and Hagar. Actually, that's her name. Thank you, Senator Beth. I didn't know you read the Bible that deeply. What happened between Sarah and Hagar, Mr. Speaker? So it's a practice steeped deep even into biblical mythology. Yet there are communities that practice that. Upon the demise, say, of the patriarch of that family, Mr. Speaker, and this I have seen in practice in many places amongst the people that are represented in this House, Mr. Speaker, challenges normally arise, and people are asked. You find members of the legitimate, or what would be considered the family that had been formally married, take to battle with the rest of the members of the family. And this includes, Mr. Speaker, if the woman who has been co-opted into the family had children of her own previously before coming into that family. And that's an area of challenge. And so many other scenarios and customary practices amongst the different people that are represented and form the society that is Kenya, Mr. Speaker. And I have seen struggle. First of all, Mr. Speaker, you know, in many communities, they consider it taboo to go and resolve, say, land matters through a court process. Many of them would rather that the village elders and members, first of all, it starts with the clan members of a particular family, you're called and try and adjudicate. If you are unable to reach an amicable solution, Mr. Speaker, you invite the village. And if the village doesn't agree, then eventually people seek court interpretation. And it was actually the High Court sitting in Kericho that made a very significant finding on the laws of succession with respect to land, Mr. Speaker. About 6 or 7 years ago, it was that High Court in Kericho, Mr. Speaker, that ruled that women could as well inherit their father's land, even when married, Mr. Speaker, if they laid a claim to it. And that remains, to the best of my knowledge, unchallenged up to date. And there have been many families that have gotten into challenges with the application of that particular section of the law or case law, Mr. Speaker, for that particular matter. And therefore, for Senator Veronica Maina to attempt to provide at least the legal basis and clean up the various sections of the law with regards to succession is quite commendable. And I want to appreciate the industry that has gone into this bill. I want to believe, Mr. Speaker, that it is in line with her practice as a lawyer, Mr. Speaker, that she has been able to point out many of these either inconsistencies of the law, Mr. Speaker, or functions of poor drafting, Mr. Speaker, that has led to difficult interpretation and challenges with application of the law. And it therefore goes without much forbearance, Mr. Speaker, that is the reason that the bill begins even by very basic issues such as just definition, even on a simple matter such as matrimonial home, Mr. Speaker. And he has provided elaborate clarification now, Mr. Speaker, that a matrimonial home will mean actually any property that is owned or leased by one or both of the spouses and is occupied or utilized by the spouses as their family home and includes any other attached property, Mr. Speaker. And it's important to give that particular clarity, Mr. Speaker, because I want to believe that wasn't the case as the matter may be. Because there are others who believe that so long as it's a property held elsewhere, many did not want that to be the broader definition of what a matrimonial property is, Mr. Speaker. But by act or by operation of this bill, once it becomes an act of parliament, that will be operation. And it's important for the men, even as you debate this, to know that this involves any other attached property. I know I'd be keen to hear what Senator Mogeni will want to say about this, and especially given that there are other details of his family which I don't want to reveal, Mr. Speaker. So, some of us can get away with the interpretation of the law. Mr. Speaker, he does not have that luxury, Mr. Speaker. Therefore, as we pass this legislation, think clearly as a man and as Senator Veronica warned us earlier, not the situation as it prevails presently, but what it portends for the future. You never know what can happen to you as a man. I see when I say that, Mr. Speaker, Senator Mtata really looked keenly at me. I don't know what plans he has, Mr. Speaker. Section 5 of the bill, Mr. Speaker, is an amendment, actually, of the Principal Act, and just cleaning up the various legislations that I said. Number one is on this issue of surviving child who's not a child of the surviving spouse. You know very well this particular issue, and many colleagues have spoken on this particular matter, what happens in funerals. We've heard all these stories and how it ends up being a difficult journey. Mr. Speaker, you know, especially we that are in this trade of politics, many times when our tour of duty on this earth comes to an end, Mr. Speaker, sometimes families have to resort to very crude means of keeping products of our industry elsewhere away from attending funerals. And I have seen even goons and vigilantes, Mr. Speaker, being hired. We have all watched, and we have ideas that come to mind. It's perhaps because people knew, and I think what people were avoiding at that particular time is the recognition that comes with being present during the day of being laid to rest. With this clarity that is now being provided by law, the way Senator Veronica is doing, even as a child that is not formally recognized in a family, you need not go and fight and endanger your life if you know that you are not properly appreciated in a particular family. By law, you're being provided good cover, and that's part of what the clarification that this proposed bill is giving. Subsection 1B, Mr. Speaker, the surviving spouse shall be entitled to the personal and household effects of the deceased absolutely and a life interest in one half of the whole residue of the net estate, and the surviving child shall be entitled to one half, Mr. Speaker, of the other. The division that comes between these two particular, treating each as separate and distinct entity, Mr. Speaker, which wasn't the case because there are other families, Mr. Speaker. What happens in the case where, for example, you have 2 or 3 sons, you have an estate, Mr. Speaker, and suddenly a child who's not part of the family of the spouse that is alive eventually shows up, Mr. Speaker. This provides coverage to them, and many families, Mr. Speaker, sometimes agree to share. But this makes it even more difficult because just a plain reading, and maybe Senator Veronica, you may need to clarify to us later on as you will be responding to this bill, whether that particular child will be counted amongst the other 3, or it's a complete separate home as such, given that the fact that this is dividing the estate into 2 between the surviving spouse and this other child, because it means 2 different things, Senator Veronica Minor, and you may want to provide clarity to that, because if, for argument's sake, a deceased person had 3 sons and their estate is being divided amongst these particular 3 sons, a simple calculation is that if another son was to show up, Senator Veronica, by dint of practice of the law as you're proposing it, then the division will now be in 2. The mother and her sons, and this other son that has showed up, being treated as another family, as opposed to being put together with the other 3 sons. You need to provide clarity, Senator Veronica. Otherwise, unless I haven't read quite properly, but it's something that I will need to understand. And I want to repeat for emphasis' sake that I say this is in public interest. No other interest, Mr. Speaker, in this. B, Mr. Speaker, is also where there are surviving children, a child who is not a child of the surviving spouse. What are their entitlements, which is what now I was speaking to, which is, number 1, that surviving spouse being entitled to the household effects, that is absolute as described previously. But part 2, the net interstate estate shall in the first instance be divided equally among the surviving spouse and all the surviving children. And that's the part that I said you need to bring it quite properly clear for everybody to appreciate and know that that is not the case. That for me, what will pass as a fair law is that if it is known that these are the children of a deceased person, and it doesn't matter from which of the spouses, Mr. Speaker, that so long as it has been clearly established, Mr. Speaker, that this is a child of the deceased, then let them be treated all as one equal family, and the property or inter-estate be shared equally amongst them. Senator Veronica will provide. In fact, it gives me more doubt and need for clarification in my mind, reading part 4 actually of 5B4, Mr. Speaker, where I described that the share of the surviving child who is not a child of the spouse under subsection 1B(b)(2) shall be held in accordance with section 41, and if there be more than one child, they shall share equally. What happens, Mr. Speaker, if Senator Veronica, keep it in your notes, what happens if even in that extra child there are more than one from different mothers as well, assuming the case that the deceased person is a man, Mr. Speaker. And the same can happen to women as well, because society is evolving. We thought that previously, when we were legislating and thinking about these issues, many of the time the laws were written with men in mind. But it is increasingly becoming clear that even women sometimes have estates that need to be shared, and there might be kids from spouses other than the one that they were married to, Mr. Speaker. And it's good because this law, as we keep changing, keeps on evolving. Section 6, Mr. Speaker, is just a cleanup of these particular laws, as has been brought out. My particular interest, just by way of completing my contributions to this bill, is on section clause 8, Mr. Speaker, where section 40 of the Principal Act is being amended by inciting the following new subsection immediately after subsection 2, which is 3, because after there's section 1, section 2, and this is now part 3. And you know, Mr. Speaker, one of these days, this is something we may need to discuss and think critically about it. I know the clerk who's on the table used to be a legal drafter back in the days earlier in his career. Still is actually, but he did it formally then. I know now he's a big man. He doesn't do this kind of job anymore, Mr. Speaker. When we do amendments to mother acts, many other times we quote them in the bill but don't refer, such that making comments or even a plain reading of the bill sometimes is difficult, because unless you're carrying the mother bill on one hand, Mr. Speaker, to keep on referring, sometimes you can lose track of the arguments that you're making. For example, in this bill, like I have pointed, section 8 is an amendment to clause 8 is an amendment to section 40 of the Mother Act. So this new clause 3 is being introduced, and you're just being told it is being added immediately after subsection 2, 1 and 2, which is not part of the bill in reading. And there's just something about it that I find perhaps legislators can end up missing the flow of what is being described, Mr. Speaker. You may not necessarily have to capture it on the bill, but maybe somewhere in the annexures or there has to be a better way of drafting these bills, Mr. Speaker, as opposed to what is being said. Anyway, back to the main point of what I wanted to say, is that this new section 3 that is being included, Mr. Speaker, is that it reads, notwithstanding subsection 1, what I have just said, section 1 is not here, where any of the surviving children is not a child of any of the wives of the deceased, that child shall. And in fact, I don't know why for this one they have used wives. Previously, in all the clauses that we have been reading on the bill, they have kept it gender neutral, which is spouse. Because, like I have observed, what passes for men nowadays passes. We're in the days of gender equity, Mr. Speaker, and the same could as well be husband, unless maybe there is a specific reason. Senator Veronica Minor, you'll explain to us. A, that child shall, A, be considered as an additional unit in determining the share of dependents in the net interstate estate under subsection 1, and B, the share of such child shall be held in accordance with section 41, and if there be more than one child, they shall share equally. Just the last point that I mentioned before I conclude on this particular matter, Mr. Speaker, the need to take into consideration cultural sensitivities. And I pointed out that particular challenge that exists between the Akamba people. I don't know if Senator Wambua will know, but at least I know Senator Beth because of her standing in by having been amongst the Kamba people long enough. Senator Wambua left his people early enough to go to school and do other things. So I'm not sure whether he knows these things. Of course, Senator Kavindu will know this as well. And I pointed out, Senator Wambua, that of the cultural practice of where women used to bring on addition other women, what is the place of such children? Because many of such women would come with kids from other either marriages, Mr. Speaker, or whatever the case may be. What will be their standing? And that was just an example. There are many other cultural sensitivities and practices which you cannot capture in this particular law in the manner that is being proposed here. What is the place of such children, Mr. Speaker? And so many other challenges that may arise to that. Perhaps, Senator Veronica, Part C will make sense maybe during the committee of the whole, or I don't know which committee will handle this particular bill, to have a Part C that takes into consideration such sensitivities of children who biologically they neither belong to the either of the spouse but are still considered to be children of that particular family, and how that needs to be treated in light of the shares or division that is taking place, Mr. Speaker, because these are live matters. Otherwise, Mr. Speaker, I want to appreciate Senator Veronica Maina for this very thought-provoking bill and hope that we shall have a fair and sober debate that the men will speak openly about, because these are issues that affect us, Mr. Speaker, and the women as well, Mr. Speaker. It's good to hear their thoughts on this particular thing so that we can have a law that ensures that no child is disinherited, either by acts of omission or commission on the law side, Mr. Speaker. With those very many remarks, Mr. Speaker, I'm used to moving. I thought I'm moving the bill, Mr. Speaker. I beg to contribute and agree to the proposals being made. Thank you, Mr. Speaker.
Thank you, Senator. Senator Eric Okongo Mogeni.
Thank you, Mr. Speaker. Sir, I also rise to make my contribution on this bill. And first, Mr. Speaker, I was mentioned, I think, adversely by Senator Cheruiyot. He touched my family and he may create an impression that other than my dear wife, Jacqueline, I have another family. I want to declare that I'm a loving husband to one wife, Jacqueline, and I have no any other wife, Senator Cheruiyot. Yeah, Mr. Speaker, I wish Senator Veronica was here to listen to me. You know, this bill was before my committee last Parliament as the chairman of JLAC. Before I was succeeded by my good friend Senator Sigei. And the provisions that are here, almost lifted from what was in that law, were very interesting. You know, we did public participation, Mr. Speaker, and we thought some of these provisions would get support of women. But it was during COVID, and we put in stakeholders together, and we said, now let's collect views from the public. And you'll be surprised, Mr. Speaker, that even on an issue like definition of who is a child, was very heated. And we had even National Council on Women, is that called NGEK? We had a feeder in the meeting. We had many women organizations. And it's not easy. to convince all women across the board to accept the child. Very, very interesting proposals came to the table, and I hope maybe Senator Veronica can benefit from what is on archives, on the views that we received from the public. You know, like what was interesting is what I heard from women who felt that we are trying to legislate for, their husbands who may be keeping other women out there. And Madam Speaker, Mr. Speaker, despite their contribution, which I really appreciated, in protection of children born out of wedlock, because they were very clear, Mr. Speaker, that we cannot throw those children to the wilderness. But they were very clear, Mr. Speaker, that a proposal to include these other children should be so clear, Mr. Speaker, that a share of what goes to these children who are born outside should be a percentage. That was just a proposal. I'm not saying that's what was on the bill, but they were so clear, Mr. Speaker, that somebody was giving an example that if you have 5 children or 6 children born in a monogamous marriage, and this was coming from women, and they were of the view that if they have contributed with the husband in acquiring some property, then their children should get a higher share than the other one. They said, fine, we don't want those children to miss, but we need to be careful how we share this property. So I've no doubt, Senator Veronica, that you'll receive very interesting views. We were not able to even finalize the bill, so it died during last session. I remember somebody said, Mr. Speaker, that there are women who can be what I think they called good peckers. They say there's an animal that is used to good picking, good pecker, a good pecker. And they were giving an example like Senator Cheriot, is in public limelight, his majority. Occasionally he has flown with a chopper to Kericho, and there could be some ladies admiring him somewhere, And the proposal was that some of these beautiful ladies may be looking for Senator Cheriot, not because they want to be married to him, but because, according to them, they felt that we were bringing in place a law that was going to entice women to go after some men who, in quotes, are perceived to be well off in society. And therefore, they were saying they will go to Senator Cheriot not because they want to be second wife, but because they are feeling that the law that has come in place makes it very easy for them and their children to inherit. So this bill will get very interesting views when it goes to public participation. So Senator Veronica Maina, be prepared to receive
Senator John Kinyo, what is your point of order?
Mr. Speaker, the senior counsel has a very good debate, but now I did not get the part of the woodpecker. Is it Senator Cheriot who's the woodpecker or the beautiful lady, Mr. Speaker?
The Speaker, from the views we received, the woodpecker is the woman who will be coming looking for Senator Cheriot to be the father of his children. It was very interesting. I hope when this public participation begins, many of you can...
Senator Crystal, do you have a point of order?
Thank you very much, Speaker. My good senator from Nyamira was doing so well until he implied that woodpeckers are usually women. Mr. Speaker, there are several women in this Senate, as an example, and we have property, we have a lot of investment that we've also made, and there can also be men who might come to woodpeck, and they do. They're called bentens, Mr. Speaker. So kindly, if they're papas, exactly, they come only for one reason and one reason only, and I would like the senator in his submission to kindly clarify that can be both men and women, and not just women alone. I thank you.
You can see, Mr. Speaker, that's why I told you that the views that you will receive from the public will be very interesting. Now, this is even another one, that it's not only the ladies, but there are also men who are waiting for the passage of this bill, and then they say, now, if I get a child with that good senator, then my children will be assured of inheriting some. That's the perception that came to the fore from the public. You know, many views. And I think it's good. It's a good debate, Mr. Speaker. It's good to have a law that is certain, so that as temptations come your way, you know beforehand that is the position in law. But then I have no answers to you, Senator Maina, but I hope that once you take this bill through a very intense public participation, you'll be able to come up with a bill that is acceptable to both the men and the women. As you have heard, it cuts both ways. There are men who may benefit and women who may also benefit. The other point, Mr. Speaker, that I found very attractive to me is this clause that talks about intermeddling. Mr. Speaker, if you have heard stories on widows especially, I don't know about widowers, but I know stories of widows who go through horrendous experiences. Mr. Speaker, you lose your spouse in Nairobi or in Mombasa, and members of the family of your spouse arrive, and they want to start sharing property, Mr. Speaker, household items, and the like. So it's very good that this bill is trying to make it very clear, Mr. Speaker, that anybody who tries to intermeddle in a property of a deceased person risks facing criminal prosecution. When a person has lost a dear one, Mr. Speaker, and they're in that state of mourning, the best that we should do to such a spouse is to be sensitive, to be kind to them, to be understanding, not to take the laws as an opportunity for us to share the properties of a deceased person. So this is a good proposal. This one, I think, was not very contentious. It was bringing clarity to the law, and it's good to make it clear, the Speaker, that if your spouse dies, the personal effects are left to you as a spouse, Mr. Speaker. There's no need of third parties coming in to try to take over properties that have been left behind by a deceased person. I think the issue of adopted children, the Children's Act addresses this very ably. It's good to know, Mr. Speaker, that once a child has been adopted, he becomes a child. The word adopted is just used for a legal process. The moment a child is adopted through a legal process, by all intents and purposes, you become a child of that parent who has adopted you. And it's good that the law of succession properly recognizes them as children. The other issue that Senator Veronica will be interested to know is this idea of trying to amend Section 35 and try to make the rights of a widower and the widow to be applied equally. The Speaker, somebody gave an example of the culture in the Maasai community, and he said, if I lose, and these are not my views.
Senator Makueni and Senator Kavindo, please, want to hear the Senator in silence.
Thank you, Mr. Speaker. I'm saying just to understand how culture can really collide. There was somebody who gave us a view on cows, within the Maasai community. And, he could not understand what this law was trying to propose when it said that if you are a widower and you lose your wife, you had one wife, that if you marry, you lose your cows. The Maasai could not understand, because it was like, even if I was to marry another wife after the death of my spouse, the cows belong to me. So there is no way you can tell me that I will lose my cow. So I don't know how Senator Veronica Maina, when you appear before the Justice Committee, you will clarify some of these cultural issues that may have a clash with the proposals in the law. But I know where you are coming from. This is an era where the boy child and the girl child wants to be treated equally. So the intention is good. You want the benefits that accrue to the widower should accrue also to the widow. If there are properties that will pass over after a process happens, the law is simply telling us, Mr. Speaker, that if a widow remarries and the property, the life interest ceases and passes over to the children, the same should be applicable to the widower. Literally speaking, what happens to a wife who becomes a widow, gets another man, and marries. And the same should happen to a man who becomes a widower but gets another woman and remarries. I think the law is just trying to bring equality to the spouses in a marriage. Again, I don't know what answers you will get, but that was a very, very interesting and emotive discussion about how you deal with the properties of a surviving spouse. Mr. Speaker, I don't have a lot to say on Clause 6, because Clause 6 is simply trying to give us how to distribute the property of a deceased person in the event that there are no children left behind, and automatically such a property should go both to the father and mother. I think what I had women telling us that time, I don't know whether that's what has been happening. What the women were saying is that there has been this tendency of mzee saying, if my daughter or child has died, then I should be the one taking the property. But the agitation was that that property should be inherited by both the father and the mother of the deceased child. I hope I'm getting it correct, Veronica. And I think that's a fair one. In this era, both mother and father should enjoy the fruits of their labor. If you lose your child, if they don't have anybody succeeding them, that property should be shared equally between the mother and the father. I don't think that is controversial. And then it is giving another, a chronology of the people who should benefit so that we don't have disputes. Finally, as I conclude, Mr. Speaker, it's also it's good to tell Kenyans also that you can take advantage and write a will. This law is addressing people who die intestate. But if you take advantage and write a will, then you avoid some of the disputes that could arise through succession. And I must pass my condolences to the late Justice Majanja, but though a fairly youthful judge, he had not even hit 50. But the moment he passed on, very untimely at that very, very productive age, his will was with a lawyer. He's a judge, but he had already written his will, and the lawyers came out and say, here is the will of the judge. His will was that he be cremated within 24 hours or within the shortest time possible. It's a good thing. Alternatively, Mr. Speaker, you can also have a process of registering your property in a manner that if one of you passes on, really there is no controversy or going through the harrowing experience of doing succession. Succession can be, a bit complicated at times. Go to the chief, let the chief write for you a letter, giving the name of your spouse, the children. You have to get searches of all the properties. It's tedious. But if you have a joint registration, if Veronica and Mr. Maina, God forbid, if they have a joint property registered jointly, if one of them passes on, the property automatically reverts to the surviving spouse. It's one way of avoiding all these, problems of dealing with succession. So it's good also to ask Kenyans, take advantage on the land laws that are in existence. You can have a joint registration where the property will automatically revert to the surviving spouse. So I look forward to engaging with this committee. I think I will also create time to appear before CK committee to give my views and proposals on this bill. I hope you will complete the task that we were not able to complete as a committee in the last parliament, so that we can have clarity on this law of succession, and make sure that you invite both male and female to appear before you and give their views. Thank you, Mr. Speaker.
Thank you, Senator. Senator Enokwamboa.
I thank you, Mr. Speaker. Mr. Speaker, I want to thank Senator Veronica for taking up this bill. I have just a few comments, beginning with a reaction to her own comment when she was moving the bill, that she doesn't expect that there will be another person in the name of a wife in a home. And yet that's a good wish, but you never know. I mean, you only know when it happens. Mr. Speaker, let's face it, the institution of marriage in this country has really come under intense attack, especially on the matter of inheritance. And the intention of this bill is noble, to deal with matters that arise in the event of the necessity to share property. But, Mr. Speaker, I also want to pass a caution to all of us and to spouses that there is more to marriage than just the sharing of property. It really commercialized marriage to the extent that now I'm hearing people marrying for the convenience of property and wealth. The Speaker, going to the bill, there is a bit of confusion, and I hope then Senator Veronica, when she appears before the committee to defend this bill and maybe to take us through public participation, some of these things will be clarified. For instance, we are concentrating on the child. You know, this bill speaks so much about the child. And I'm asking myself, are we talking about child also referring to a dependent? Are we talking about child also making reference to a person who is entitled? Or are we talking about child as defined by the law? And if you're talking about child as defined by the law, then the question arises, if you are over 18, are you still a child? And are you entitled to the provisions of this bill? Because this bill is talking about a child. And we all know that we had a very interesting case, and I don't want to mention names, of a 52-year-old child, who came up and said, I also want a share of my father's inheritance or property. So is that also a child in the definition of this bill? Or or what exactly are we talking about? Now, on the matter of intermeddling, I'm happy that the bill, sponsored by Senator Veronica, is trying to challenge some existing cultural norms and practices that really maybe should not have any place in today's institution of marriage. The issue of people invading the households of deceased persons and cutting away, property. And it will be remembered that in some areas it's not just even cutting away property. They even appropriate the surviving spouse, So it's good to provide clarity on the matter of intermeddling in the event of a spouse passing on. Now, Senator Veronica, there is a challenge. There's a small challenge. This bill speaks about inheritance or passing on property and wealth in the event of death. But you see, you should also be alive to the fact that, and I know this because you also subscribe to the same faith as I do, that the institution of marriage is complete at the tying of the knot. Once a man is married to a woman, that becomes family. Now, according to this bill, it's a bit too prescriptive because it says that when one spouse dies and the surviving spouse remarries, then they lose ownership of the property that was acquired from the first marriage. And the question that you should be asking yourself is, if death occurred before a child came and the surviving spouse remarries, where does that property go to? So the reason for remarrying should make a difference in determining where the property, or the sharing of the property. Now, Senator Cheriot, in passing, brought up a very important conversation that I don't know how Senator Veronica will handle this. In some customs, and I heard him say he doesn't know about whether I am accustomed to that. It is happening even now. It's not like it's something that has stopped. There are situations where a married woman, a wife, would bring another woman into a homestead, what you're calling the matrimonial home, and that woman who has been brought, in most cases, will come with children from other fathers. And when they come, they become part of that family, but there's no biological connection between them and any member of that family apart from their mother. Now, in the event of the passing on of their mother, how will you treat such children? Are they also children in the definition of this bill that we want to push into law? Or are they going to be treated differently? Lastly, is a matter that has been mentioned by Senator Mogeni. The law recognizes legally binding wills, a will that is written by a spouse, especially on how they want their property to be shared upon demise. Now, what do you do, Senator Veronica, in a situation where a spouse who has passed on leaves behind a legally binding will whose provisions go contrary to the provisions of this act? When it says I'm sharing my property among my wife, my son, my daughter, and the other daughter. And this is how this property is going to be shared. But because this bill is prescriptive, it says that half of the property will go to the surviving spouse, and the other half will be shared equally among the children. What happens if the will, legally binding, speaks otherwise? So those are some issues that I think they will need a conversation, and I think I'm very sure it will happen in public participation. But just summarize and say that it is okay to debate this bill and push it into law. But I just hope that this will not be the reason that people will want to enter into the institution of marriage, where then property becomes the guiding principle. You know, this man or this woman has got so much money. If I get married to them, I'm likely to benefit from their wealth upon dying. And we've heard Senator Madago is disturbing the mover of the bill, and she is taking very important notes. Speaker, protect me from Senator Madago.
Very well, you can continue.
Thank you, the Speaker, for protecting me. So then what happens in that eventuality? Because again, we have also had, we live in this country, we have also heard of people, spouses, who get into the institution and facilitate or fast track the departure of their spouses from earth so that they can inherit the property. So even as we discuss this bill, let it not be an avenue that people want to use to get in the institution for purposes of just inheriting property. Otherwise, it's going to be a very interesting discussion, especially in public participation. I hope you will invite us so that we can also listen in and make whatever contribution we can make. The Speaker, I thank you.
Thank you, Senator. Senator Mudhama Agnes Kavindu.
Thank you, Mr. Speaker, for giving me this opportunity to contribute to this amendment bill of succession. And Mr. Speaker, I'll be very brief because many of the points that I had has already been spoken into by the other senators who are before me. But Mr. Speaker, kindly protect me from Senator Manso so that, thank you. Sorry, Mr. Speaker, I'll be very short and very brief and to the point. The law, the customary law that you've had Cheriot speak about and Arun speak about and Wambua,
is very true. It's a reality, and it still goes on in Ukambani. And there is also another saying in Ukambani that says, whoever marries your mother is your father. That means there are husbands who marry wives with children from other families. And once those children come to that family, they are owned by that family, and they become part and parcel of that family. And they, on death, they inherit like the biological children of that family. And what I want to say is that this amendment bill is very, very timely, because when we were doing the public participation on the 1998 bomb blast, when we were calling the stakeholders to come and share with us their experiences, there are women who told us that after their husbands died during the bomb blast issue, the in-laws chased them from their homes. To date, they have nowhere to stay. So this bill will protect such women and their children. So I really want to take this opportunity and congratulate Senator Veronica Maina, my friend, for coming up with this amendment bill. Mr. Speaker, 2 days ago, I was also called from Kiva in Masinga sub-county in Machakos County, and told that there's a PWD husband who married the first wife. The first wife went, he married the second wife, and she was, I think something happened and she was sent home by him plus the relatives. And he has the third wife now. And as we talk, Mr. Speaker, what really saddened me is that this second wife went to court and got a court order to come and exhume a body of a son of that man from that land, because she claimed that the land belonged to her and her ex-husband. And I thought and I said, which judge could really give such a ruling of a son who belongs to the father, and that land belongs to the father, and the claim is that this land should be sold, and they share the produce, the money that they will get from the land, both of them, the husband and the wife. And yet, in that marriage, there are 3 wives, which, if we follow the law, should be sold or should be divided into 3. And whoever wants to sell their part, they sell, but it should not. I don't see any point of her coming to exhume a body of a child of that family so that she can sell the land. So this amendment bill will protect such children who are very vulnerable, and also people who are poor, who cannot buy their way in courts, because I would think that that is corruption in the highest level, for a judge to give an order for a body to be exhumed from the son's home where he was born by his father and his mother. Mr. Speaker, many of the points have been spoken, but I will ask Senator Veronica to also do an amendment of the matrimonial property at divorce, because most of the wives who are just at home and they don't work, they really suffer when it comes to divorce, because they are told to show their contribution as tangible contribution. And yet they are in that home, they are doing every donkey work, they are giving birth, they are taking care of these children, they are taking care of that husband, and that should be their contribution on matrimonial property. Thank you, Mr. Speaker.
Thank you, Senator. Senator Jackson Mandago.
Thank you very much, Honorable Speaker, for giving me the opportunity to contribute to this matter. But, Honorable Speaker, before I speak to what I want to speak about these amendments on this bill, I don't know whether a definition of work for a spouse would include giving birth to children, but I'm saying that's a debate for another day, Honorable Speaker. Honorable Speaker, unfortunately, Senator Aaron Cheruiyot and Wambua have left the chamber, but when I heard their contributions, Honorable Speaker, Senator Aaron seems to have been worried of the future or the past, Honorable Speaker. And when I looked at him contributing, I thought he was reminiscing his days in Moi University. And you know, Honorable Speaker, university students engage in so many activities. Honorable Speaker, on these amendments, first I want to thank Senator Veronica Maina for bringing this subject matter, which is a matter that touches on daily living in all our communities in this country, Honorable Speaker. And the matter of succession, Honorable Speaker, has been a very emotive matter. But Honorable Speaker, most importantly, is the process of succession that sometimes takes so long. And Honorable Speaker, as we speak today, a lot of assets and resources for families are held in abeyance. They cannot be accessed or used, and these resources run to billions of money that would have positively contributed to the economy of this country, Honorable Speaker, and to the individual lives of those families that are involved. Unfortunately, because of succession matters, disputes, and so forth, you find even the would-be beneficiaries would suffer for even more than 10, 15, 20 years, to the extent that by the time the matters are resolved, Honorable Speaker, all those are meaningless, as some would have also even themselves died in the process and complicate even the matter further. Honorable Speaker, especially on death, the issue of disposal of assets, the rush to grab and so forth has been witnessed in many occasions in a number of families. But what worries me, Honorable Speaker, and I want to thank Senator Veronica for bringing this up, is that we have so many young widows in this country who probably they have just been married, they have a child or two, and I don't know what is happening to our beliefs as communities, because we are Africans and Africans are business, and we had our African cultures of addressing the matters. And from the community I come from, Honorable Speaker, once a woman is married, whether she has a child, one child, or many children, she is already married to that home, and there are some entitlements that comes with that being married. But what we have witnessed of recent past, Honorable Speaker, and it's really quite unfortunate, is that you would find a very young widow with one of those children, probably they have not even gone to school, being ejected from that family with nothing, and sent away with the children to go and take care of, while probably the husband or the mother or the wife, Honorable Speaker, had assets and resources that would have been used to bring up these children. Therefore, Honorable Speaker, this debate is timely, and it's a debate that I would want to encourage Senator Veronica, particularly during public participation, to give it adequate time and publicity, because these amendments could probably even help this country now unlock the many resources families are not able to access because of the disputes that have come. Honorable Speaker, on the issues of children, Honorable Speaker, and surviving children, vis-a-vis children, and I want to say this because I think we need to define. Sometimes I see people say children born out of wedlock, and I don't know what. I think children are children. And my encouragement, and I would want to later engage Senator Veronica Maina, is to see how these amendments can also be linked to the rights of children, even in determination of land matters, Honorable Speaker, because the reason in this country we have so many women who say we are single mothers, and I know the IVF technology and others just came in recently, but we know the issue of single mothers has been with us for quite some time, Honorable Speaker. I hope part of these amendments will encourage men to take responsibility of their children, Honorable Speaker, so that we don't have, yes, a lady can be single, not married, but have children, but let those children know their father. And this is how also it will help, when it comes to succession in solving some of the matters, as opposed to a situation like what the Senator for Makueni was saying, that you arrive in a funeral, then you look across the tents and you find a brigade of people you resemble one another, and you've never met, and you don't know what would happen next, Honorable Speaker. If we encourage openness and responsibility, and we make sure that all children are given the opportunity to know their identity, and encourage the ladies not to hide the identity of the fathers of their children, Honorable Speaker, it would contribute to resolving some of these matters. Honorable Speaker, in a situation where one of the parents, of course, dies, or one spouse dies, and the other decides to remarry, I would really want to encourage Senator Veronica Maina that is an area that needs to be given critical thought of how the resources that was left behind is going to either be shared or used to bring up the children that have been left behind. Honorable Speaker, we have seen in a number of occasions a situation where when a mother or children dies, the man is left after 1 year or so, he gets married, and Honorable Speaker, what follows is that the children whose mother died are mistreated. Some are battered. We've witnessed situations where children have been beaten, use hot iron to put marks on their backs, and finally those children lead very distressful lives. I think, Honorable Speaker, even as we consider this bill and amendments, Senator Veronica Maina, we also have to now put into consideration such situations so that if you are to marry again, we should consider that as a fresh marriage and see how then at that point the resources that were available for that family and for those children, Honorable Speaker, would be used to make sure that the welfare of those children is well taken care of. Honorable Speaker, we are also living in interesting times, particularly for those of us, Honorable Speaker, who have led an urban life, probably for quite a longer period of time, and for one reason or another, we have either decided to do away with our cultural beliefs and norms, or we have forgotten all about them, Honorable Speaker. To the extent that, Honorable Speaker, you will witness in families where there are disputes of succession, a situation where you have a dispute as a family, and let me say, if it is myself, Honorable Speaker, and I have sisters who are married, and Honorable Speaker, during the discussion, of the succession, the son-in-laws are part of those discussions, Honorable Speaker, making it, extremely difficult to resolve some of the family disputes that will arise out of succession matters. It complicates the matters further. So I want to encourage Senator Veronica Maina to also look into who would be engaged so that it is not an open field and everybody comes, you are just a neighbor and you want to be part of the process of that succession and so forth. So I think we also need to look into deeply. And as we do this, Senator Veronica Maina has just said earlier, the public participation of these amendments should be given considerable amount of time so that we can have even opportunity, to engage and reach out to various communities, because other than the law that we develop, we have the norms and cultures and customs of communities in this country, some that are very rich, Honorable Speaker, and have actually helped to resolve most of the issues, particularly when we talk about alternative dispute resolution, Honorable Speaker. Most of the time, it involves a sitting of community elders to consider those matters as per their culture and cultural norms. And Honorable Speaker, we have witnessed very fair decisions when, our cultures and our norms are applied. I would encourage Senator Veronica Maina, because this country, we are not too many communities. We are less than 50 communities. And we have a whole organ of the Inter-Community Council of Elders, which I would encourage Senator Veronica Maina to even try and engage them, so that, you know, we can balance the views of the various communities in the amendments that we are putting in place, Honorable Speaker. Honorable Speaker, I'd also want to say that the issues of the will, Honorable Speaker, we have seen and witnessed so many disputes or people disputing the will that was written by deceased persons, and resulting into so many long legal battles, Honorable Speaker. Honorable Speaker, I would want to ask Senator Veronica Maina to also think, and I would want to do some further research and appear before the Justice and Legal Affairs Committee, Honorable Speaker, on this matter of wills. I would suggest, Honorable Speaker, going forward into the future, so that resources are not locked for a long period of time because of disputes or disputing the will. If we have the registrar of deaths and births, why don't we have a registrar of wills? So that everybody can have a will, and you are asked to review after every 5 years, and it is kept at the registrar of wills, who, upon confirmation of your death and registration of your death, your will certificate would be released and it becomes fine, Honorable Speaker. The courts can use that to make those decisions and reduce the time it takes to decide on succession matters, Honorable Speaker, that leave families so vulnerable for longer periods of time. Honorable Speaker, particularly in polygamous families, and of course the polygamous families we have today, we have a bit of challenge because some are not properly formalized either culturally or in a legal manner. But we have seen situations where some of the spouses in those polygamous families, Honorable Speaker, are chased away. Their children are denied their rights to go to school. And I think we need to resolve that. We need to really look into those amendments that will make sure that none of the desirable beneficiaries would miss the opportunity to benefit. Honorable Speaker, the issue, coming back to the issue of the wills, Honorable Speaker, and distribution, it would serve this country, and I would want to encourage the Kenyan population to take the issue of the will seriously and positively, Honorable Speaker, so that in any eventuality, there is minimum room, you know, for disputes to arise. And I would be following up this, Honorable Speaker, under the law of succession and inheritance, to make sure that children have no right to begin asking for inheritance from me as a parent, Honorable Speaker, when I am still alive. And I think we should even make it very clear, Honorable Speaker, that as soon as a child turns 18, they know they're independent, they are Kenyans, they're supposed to stand on their own, and they're supposed to also work for their wealth, Honorable Speaker. Unless wealth that was inherited from your grandfather and so forth. But, Honorable Speaker, what I've worked for, it should be at my pleasure and, to decide how I want to, you know, to gift what I have, so that we don't do laws that will encourage children, you know, sending us early to the grave, because now there's opportunity to distribute as soon as you leave, because the law says you are going to get this automatically, you are going, regardless of probably what has happened. I think we have to make sure that the law takes care of that, so that also we have a society that does not then use the law, Honorable Speaker, in a negative manner. Honorable Speaker, and just as I said, and I just want to emphasize to Senator Veronica Maina, in a situation where one remarries, the issues of the assets that was acquired in the previous marriage, Honorable Speaker, should be looked into so that the children or the spouse or the parents who probably are dependents of the deceased and are not disadvantaged. Honorable Speaker, I want to end there, but encourage Senator Veronica Maina to really give it a thought in terms of giving it sufficient time for public participation for these amendments because they are very critical and answers to the challenges that we are currently going through as a nation. Thank you, Honorable Speaker.
Thank you, Senator. Senator Danson Mungatana.
Thank you, Mr. Speaker. I want to, first of all, start by thanking the Honorable Senator Veronica Maina for bringing this amendment on the Law of Succession Act. Mr. Speaker, many of us who are practitioners of the law, we have grappled with these difficulties. And I know Honorable Veronica is also a practitioner of the law, and I'm very happy to see that she has used her experience of many years to try and resolve the issues that we face all the time in the succession courts. Mr. Speaker, one of the things that people face is when parents, especially when the unfortunate things like the death of both parents in a road accident, in a plane crash, occurs, and they have children who are expecting the parents to come back home in the evening or from their travel, and all of a sudden they don't have parents. They woke up in the morning, Mr. Speaker, and in the evening they were orphans, while in the morning they had both parents. Mr. Speaker, these are real issues that I have personally dealt with in my law firm. Now, how do you protect those children? The children, in the morning, they were protected under the protection of both their parents. In the evening, there's a plane crash, and they're waiting for their parents to come, and there is nobody going home. So, the intermeddling that we are talking about here, which has been introduced, children find themselves completely exposed, completely unprotected. And unfortunately, some of the relatives who may not have a lot of goodwill on these children, they come and remove them from their property. And many times they tell them, you come and live with auntie, you come and live with uncle. But in fact, the intention is to work their way through to get the property that was entitled to those children. I know of a case, Mr. Speaker, a very successful couple that lost their lives, both of them together. And, we have had to really look after those children until now. Now they are big children and they have come into their own, their parents' property. But, Mr. Speaker, assuming that those children were, their parents had not planned for eventualities like those, assuming that it is just like most ordinary Kenyans, that they live believing that they will reach 80, they will reach 75, and something like that happens, the children become extremely exposed. Mr. Speaker, therefore, I'm standing not only to support this bill, but to use the floor of this House, Mr. Speaker, to speak to those Kenyans who are listening to me. The time has come, and in these modern times, we must do two things. We must learn to file our KRA returns every year, and at the same time, we must learn to list what we have for that year and to update the will that we have. You and your wife must keep thinking about these kind of eventualities. It is very much an African, Mr. Speaker, to think that you are going to die, to talk about death. In some of our communities, it is actually a taboo to discuss your own death, to plan your own death. That is why it always makes news when someone says, when I die, this is the grave that I'm digging for myself. this is the casket that you are going to use, and this is the way I want to be buried. Ordinarily, this is not very African, but I'm standing on this floor of this house to tell Kenyans that time has come. As you file your returns, also look at what you have and sit down, have a business meeting with your wife or your partner or your partners, whatever the case, and think about if something should happen and you are not there, if something should happen and your wife is not there, what is the best case scenario? Mr. Speaker, an example has been given here of the Honorable Justice Majanja, who said in his will that he was going to be cremated, and within a very short time, within hours. I remember one of the other very famous bishops, Archbishop, I believe, Manasseh Kuria, also when he said, I want to be cremated, I don't want to be buried, I want to be cremated. It was a shock to us. But these prominent Kenyans are communicating one thing. Let us plan as we live and also plan when we die. Let us do like they did. And the most recent example is Honorable Justice Majanja, who I proudly say is a product of the Great Alliance High School, like myself. Mr. Speaker, plan so that in case this eventuality happens, what are we supposed to do? Who are the lawyers that we should go to? What are they supposed to do? And Mr. Speaker, if we go that way, you will see that even these amendments that Honorable Senator Veronica is talking about here become things that we can deal with. Because if you have properly planned how your home, your matrimonial home should be treated upon your exiting from the earth, Mr. Speaker, we would not have the problems we have here. We would not even need to have this amendment as far as intermeddling is concerned. But I want to thank Honorable Veronica because she has thought about these amendments. She has brought them before this House. And I really wanted to emphasize the fact that let us plan. As we plan for being alive, let us also plan for when we have departed from this earth. This bill, Mr. Speaker, if you look at the memorandum and objects of the bill, is also discussing about court decisions that have been made by the High Court. The Constitutional Court has declared sections of the Law of Succession Act as being discriminatory on the basis of gender. So that, Mr. Speaker, the life interest upon remarriage was not lost for widowers, but for widows, it was lost. And I know arguments have been made here for and against the African customary law as far as interpretation of this amendment is concerned. But, Mr. Speaker, when we look at this thing carefully, when you're alive and your spouse is alive, and you say you've worked very hard and you have brought a property that you have given for rental purposes, Mr. Speaker, it is very unfair that if the husband should pass away and the wife stays 3, 4, 5 years and remarries, her life interest in that property gets lost. But if the husband, if the wife passes on, the life interest of the husband remains. Mr. Speaker, this is discriminatory, and I thank the Honorable Senator because it has come at a time when it is curing this discrimination. Mr. Speaker, we are going towards an era where we need to recognize that our partners, in fact, are part and parcel of ourselves, And the law now must move in that direction. The law must recognize the position of our women. Mr. Speaker, just 2 weeks ago, we were in the Pan-African Parliament, and one of the things that was being debated at the Continental Parliament was a question of gender discrimination. In leadership, gender discrimination. In property ownership, gender discrimination. Even in appointments, gender discrimination. Even in the financial sector. And Mr. Speaker, this bill is one of those that is trying to bring that equity that we have been talking about for a long time. And I know it will take time before we actualize the realities of the equity that is required. But the more we talk about these things, the more we debate them, the more they become acceptable. That the other gender, the women, and ourselves, we have equal responsibilities. And there is no basis for discrimination, irrespective of our customs. Some of our customs are very good. Some of our customs need to go with the times. Because I know other people have argued that customs should take precedent in some of these matters. But I believe that customs should also be able to move with the times. And it will be good for us to pass this law, support this law, so that those offensive sections 35 and 36 of the Act, the Succession Act, can be removed as the court had ordered in its judgment. Mr. Speaker, I want to emphasize another thing, that if we can sit down and discuss these matters while we are alive, we can agree, even the properties, Mr. Speaker, just like bank accounts. If you have joint bank accounts, even if you pass away, Mr. Speaker, there's no, the rigmarole of going through law of succession just to access the funds to keep the children or the family moving are not there. So it is time for us to consider having joint accounts. And I know many of us would argue that, there could be a divorce, there could be so many other things, maybe the issue of trusts exist. Then you don't have to do all the accounts to be joint. You could have some joint, some independent. But joint accounts help to resolve some of the issues that go around succession. Joint accounts between our spouses, they help to resolve some of the issues around succession because they make that property easily accessible. That property, and I mean the cash, the property in the cash, easily accessible in the bank. Mr. Speaker, also joint registration of properties, they also help to deal with the rigmarole of succession, so that in the event that either spouse passes away, the other one who is holding the joint registration continues with the property in full ownership of that property. And Mr. Speaker, this also helps. And in terms of planning, Mr. Speaker, even when one of the spouses passes, especially if it is the man and he was the breadwinner, and you left your wife and she has access to the bank's accounts because they were joint bank accounts, at least some of them, and she has access to the property, including the matrimonial property, because you had registered it jointly, then, Mr. Speaker, even you, as you are going to the other world, you live with peace. You live knowing that your family is taken care of. The days of trying to register your brother, your cousin, your whatever, as the person who should take over in case anything happens, those days have been passed with time. So, Mr. Speaker, I think some of these innovations are very good for purposes of making sure that we don't have the problems that are associated with death, which are intestate. That is, you've died without a will. Mr. Speaker, also, you know you have 7 children, and you have plots, you have land, you have bank accounts, you have properties all over this country and maybe outside, what is the problem with you and your wife assigning these properties to the children when you are alive, so that when you are exiting, you are able to clearly, everyone is able to clearly see, this is what mom and dad wanted for me, for number 2, for number 3, and so on, instead of leaving things hanging. So I'm urging people to write their wills. And if they don't write their wills, then while you are alive, if you don't feel like that is probably your custom, doesn't allow you to plan for that, then while you are alive, make viva voce decision. Make those agreements. Be in joint accounts with your wife, with your spouse. Transfer the properties to the children while you are alive, if you don't want to plan for a will. So there are 2 options. Let us not engage so much, and Kenyans listening to me, let us not waste a lot of our money in these succession battles. Mr. Speaker, some of even our colleagues, very notable colleagues, we have read and we have seen people who have enriched themselves, lawyers who have become very rich from the estates of some of our colleagues. And the children are suffering, the grandchildren are suffering. Some of the grandchildren are even dying poor. They can't pay medical bills. And yet the father, when we were here, they worked very hard. They did so many things. They were very prominent Kenyans, and they took time to arrange, to accumulate wealth. But then when they are gone, because they died without organizing themselves, these lawyers have gone on to accumulate wealth from the wealth that they left. So, Mr. Speaker, I am repeating that we need to plan for our families, plan for death, and plan for the succession properly. But this bill is going to help those who will refuse to plan, is going to help interpret some of these sections, and it's going to bring equity between spouses who have lived together or who have been married for many years. Mr. Speaker, I think this is a beautiful bill, and with those very many remarks, I wish to support. I thank you, Mr. Speaker.
Thank you, Senator. There being no other senators wishing to contribute, I ask the mover to reply.
Thank you, Honorable Speaker. And let me, at the very onset, thank all the senators for their insightful, the honorable senators for their insightful contributions towards this very important amendment. And let me begin by thanking Senator Sigei for his remarks and giving the update on how far the JLAC committee is in preparing the report that had considered some of the stakeholders' views that had been sent to JLAC on the stakeholders' engagement. And let me also thank the majority leader for his very wise remarks regarding the import of Section 40 and 41 of the Succession Act. And let me say at the very onset that in the law of succession, it's an act of parliament that deals with the distribution of the estate of the deceased persons. It specifically angles on succession matters. It deals with assets and liabilities of a deceased person at the time when that person is departed. And it has 2 big, broad branches in the manner in which it deals with these matters. There is the testate part. That's when a person is deceased and has made a will. And it also has the intestate part, which is the larger. It contains more provisions of the intestate, because when a person becomes deceased and they have not written down the will, then there are different rules that are engaged. And that is why what has been amended right now is in relation to mostly part of the sections that deal with the uncertainties when somebody has died and has not left a will. And that's why when you see the amendments we are discussing today, it's not because the concentration is more so on the property. It's because the branch of law of succession itself deals with succession matters when somebody has already passed on. And that's the reality of life. We live someday and we depart someday from this life. And when we depart, how the estate of the person who departs is organized is managed under the law of succession. That's why it's called the law of succession. So thank you, Majority Leader, for raising an important question on how we present bills to this House, especially when we are amending sections of law, that when we do the cross-reference, it's important that we have the sections that are being cross-referenced. I guess that is for the Secretariat to improve on how we present the bill so that it's easier for honorable senators to be able to debate. But if I may look at one of the questions that the Majority Leader, Senator Aaron Cheriot, raised, it's in relation to section 40, and this is a section that deals with the system of law that recognizes polygamy and the estate of a deceased person in the event that they die when they are in a polygamous situation and without a will, and it provides for distribution of that estate according to the houses or what you call units. For example, if a deceased had 2 wives, and wife number A has 3 children, wife number B has 4 children, and the wife number A with 3 children plus herself, those will be 4 units. Wife number 2, who has, let's say, 4 children plus herself, those will be 5 units. So each person is treated as a unit in law. So if you have an additional 1 child, then that child will be treated as 1 unit. And they are not going to be said that a child who comes out of the first home takes half by herself or himself just because they come from another home. No. If the child is 1, they'll be treated as 1 unit. If the other family has 3 children, they'll be treated as 3 plus 1, the 1 being the wife. So they'll be treated as 4 on the first house and 1 on the second house. That will be 5. So each person gets an equal treatment in law. And how do we deal with the distribution of that estate? If, for instance, you say the estate was worth 2 million shillings and there were 10 units, then it will be divided among the 10 units. Let me also thank Senator Omugeni, who has extensively dealt with the issue of this amendment. There was an attempt in the previous Senate to do some amendments to the family law and succession, but it did not succeed. And we hope that this will eventually see the light of day. He raises an important question on people considering to write down their will so that they attest it. Now, when a person writes down their will, the person who is doing the will, that's the testator, puts down how he would intend the estate to be distributed among his dependents or among the beneficiaries of that estate. It makes it easier for everybody. So what happens if such a person dies and they've already written a will? If that will is legal and is not challengeable in court, then it makes it easy for distribution of the estate, because the court will basically adopt the will and then it will proceed to allow distribution of the estate with the will describing how or prescribing how that distribution should be undertaken. It makes work easier, and I'm happy that the example of our Honorable Judge Justice Majanja has been used to show how when a man has planned his issues, then everything becomes a lighter burden to those who are left surviving. Senator Enoch Wambua, also thank you for the contribution and thank you for the concern you have raised that a marriage should not just be about properties. Marriage actually is a God-given institution, and the concentration should not be on property. However, properties cannot be ignored because for that marriage and that family to be able to provide for the children, there are those things that must be done for life and subsistence, and that's where this question of succession comes in. But definitely this law does not by any chance make it easier for people to determine that they'll get married because they want to inherit property. Indeed, property should be the last thing that people should be considering. I think marriage and choice of spouses should be based on love and should be based more on God's command, not on the urge to acquire property. If someone just wants to acquire property, then they would rather look for business ventures, but not tuck and hide behind marriage. So I quite agree with you. But I would also want at the very onset to clarify that the law of succession, what we are introducing here is an amendment. It has been in existence. So even before this amendment, the law does exist, and it's the one that guides the courts in how the estate is being distributed. So maybe I do not see these amendments encouraging people to treacherously look for spouses, either men or women, to marry just because they want to acquire property. But in the event that there is a demise which would be an unfortunate incident, then there is a guideline in law to show how that property should be distributed. Senator Agnes Kavindu raised an important question of how in-laws sometimes can become wild and chase out the family, and that also the protection that is being offered by the amendments would maybe deal with these issues. So we hope that we can clarify and reclarify the law until we are in a happy state where the implementation is easier. And she also raised the need to amend the Matrimonial Properties Act. That's an important debate because we know there is jurisprudence that has come even from the Supreme Court regarding how the court determines what is the contribution of each spouse towards a matrimonial property and what is defined as a matrimonial property or matrimonial properties. That's a challenge that we will be taking. Senator Madago raised an important issue on cultural practices that we need to consider, whether there are principles within cultural practices that we need to reduce into principles that can help us improve our jurisprudence or even improve our legislation. And definitely that will be taken up. And Senator Danson has also brought out the question of gender equality, which is the trend that the world is taking, including at a continental level and at a global level, that we make it a level for both genders to be treated equally and to be able to enjoy. Each gender should enjoy what another gender is enjoying, and also brings out the need for people to plan and plan and be able to reduce their wishes into a will. How to prepare a will, where is that will deposited? In fact, one of the senators asked whether we should have a registry for wills. For the time being, a will, once it's written down, of course, can be deposited with your lawyers or can be deposited in the bank or in a safe place where you know that a person holding the will is such a person of integrity that even when the family says ni mama fulani ama ni baba fulani who is keeping custody of that will, it is credible and believable and will not be treated as a fraud. I have taken into consideration all these proposals and the need to further refine the amendments, and I'll be presenting them to JLAC so that at the committee of whole stage we can effect the amendments, and so that when the JLAC committee brings the report, then they'll be considered wholesome and we can reclarify the critical issues, even the issue of children who are born not by the spouse. Like, for instance, if a woman gets married with 2 children and those children don't belong to that man, are they entitled to inherit? Of course, there is what the jurisprudence has been driving us to see, and what the jurisprudence has been set by court is to say that some of the children, unless they were recognized and adopted by the man who has married their mother, then maybe they will have to go back and inherit with their father. But those are clarifications that we will need to put as we look at the further amendments as proposed by senators. That is one of the things we are going to do, so that when the report comes back to the House at the point where we have committee of whole, these amendments can proceed to be effected. And then, of course, I like what the senators have raised, different ways of dealing with when the planning is done in a tested manner, different ways with dealing with the wishes of the deceased, like the issues of cremation, which in an African community, initially you could not have mentioned the word cremation, especially to some of the community members, including ourselves, but it's become something that people have now adopted. Too many Kenyans have adopted to cremation. So all those issues have been raised as a challenge that even as we amend, we consider wider amendments in this during the process of these amendments that I have proposed. So I want to thank all the senators for those insightful contributions, and I'm looking forward to discuss further, receive the contribution from the senators who've undertaken to come to the JLAC on stakeholders engagement. We discuss some of these concepts further and come back in with relevant amendments. And with those few remarks, I beg to reply. And I would hope that we will be given a chance to come back later, have a chance to come back later to be able to do the amendments, Mr. Speaker. And pursuant to Standing Order 66.3 of the Standing Orders, I now beg to move that we put off the question on the motion, or the putting of the question on the motion be deferred to a later date to allow for these discussions. Thank you.
Thank you, Senator. And we shall defer putting the question to a later date. Let's proceed to the next order. Next order. What is your point of order? Next order.
Order number 19, the Public Holidays Amendment Bill, Senate Bills number 31 of 2023, second reading.
Order is deferred. Next order.
The County Assembly Services Amendment Bill, Senate Bills number 34 of 2023, second reading.
The order is deferred. Next order.
The County Public Finance Laws Amendment Bill, Senate Bills number 39 of 2023, second reading.
That order is deferred. Next order.
The Energy Amendment Bill, Senate Bills number 42 of 2023, second reading.
That order is deferred. Next order.
Order number 23, motion, report of the Standing Committee on Finance and Budget on the status of implementation of projects funded by the conditional grant for the construction of county headquarters.
The chairperson is not here. That order is deferred.
Order number 24, motion, report of the Select Committee on County Public Accounts on its consideration of the report of the Auditor General on the financial statements of West Pokot County Assembly for the financial year 2018-2019, and report of the Auditor General on the financial statements of Isiolo, Kiambu, Kitui, Marsabit, Narok, Nyamira, Trans Nzoia, West Pokot, and Murang'a County Assemblies for the financial year 2019-2020.
That order is deferred. Next order.
Order number 25, motion, report of the Select Committee on County Public Investments and Special Funds on its consideration of the audit reports of the water service providers for the year ended 30th June 2019, 30th June 2020, and 30th June 2019.
That order is deferred. Next order.
Order number 26, motion, report of the Standing Committee on Health on the inquiry into the alleged irregularities in the procurement of long-lasting insecticide-treated nets at the Kenya Medical Supplies Authority.
That order is also deferred. Honourable Senators, there being no other business on the order paper, the Senate stands adjourned until tomorrow, Wednesday, 17th July 2024 at 9:30 a.m.